Commentators point to gaps. Few address specific issues concerning such things as the privacy of children, but they point to gaps, lack of transparency and independence in the investigation of complaints, overlap and differences between codes and weak enforcement mechanisms, though ACMA can seek enforceable undertakings. The Australian Press Council complaints process, for example, has no power to penalise or make an order against a publication. No power whatsoever. No one has ever been expelled from the MEAA for a breach of standards. Media organisations defend the arrangements, arguing that change is unwarranted and unnecessary. Australia's Right to Know, for example, stated, media privacy issues are best managed by industry-specific codes of practice. The existing media privacy framework provides all the appropriate mechanisms for dealing with privacy in the media. The current media privacy framework is effective and working well, it says. This is evidenced by low numbers of complaints, investigations and breach findings. In addition to existing codes of practice that deal specifically with privacy, media in Australia are subject to a wide range of federal and state laws which protect private rights and interests, it says. It goes on to say, any proposal to enhance the rigours of existing media privacy regulation must be limited to addressing specific identified public interest concerns regarding the media's treatment of privacy issues. Well, the fact is, the system of self-regulation set up under the general exemption from the Privacy Act is more or less a set of hometown arrangements for the media companies. That's what it is. With print media, it is established around an organisation that lacks any power of coercion or penalty and which operates in the main to excuse the transgressions of its members. Even the funding of the Press Council is dodgy. Because it is funded by publishers on a formula based on circulation, News Limited is a major contributor. That is, the body which is adjudicating on complaints is funded by the largest newspaper group, where obviously many of the complaints must arise in the first instance. Dennis Muller tells us that the Press Council's own research, this is important, the Press Council's own research shows newspaper executives are much more likely to be satisfied with the outcome than are complainants, or quite so. But damningly, the former chairman of the Press Council, the recently retired Professor Ken McKinnon, said on the occasion of his departure that the media failed, and I quote him, to live up to its own rhetoric on ethics, privacy and independence. It's a pretty damning thing to say, I should have thought. David Salter, in his The Media We Deserve, said about self-regulation, it is the most astonishing yet unremarked hypocrisy of the Australian media. An industry that devotes so much of its energy to questioning the motives and morality of others nevertheless believes it can and should be trusted to regulate itself. Our media wish the full force of the law to bear down without fear or favour on everyone except themselves. The faintest suggestion that the output of our print, radio and television empires might benefit from some legislative attention is invariably met with the rolling thunder of outraged editorials, all protesting the evil of any such assault on the sacred freedom of the press. Salter went on to remark that the philosophical justification for self-regulation stretches no further, he says, than that most over-quoted principle, freedom of the press in the public interest. That's it. He went on to say freedom of the press cannot also be freedom to lie, freedom to deceive, freedom to unlawfully incite or alarm, or to purchase it, or to pursue a criminal purpose. He said, and this I think is a powerful sentence, the only real regulatory power is the law. And the law is usually at its best when journalism is at its worst. The fact is, it is naive in the extreme to believe that a clutch of large companies, in this case media companies, will or can conduct their affairs on some sort of trustee basis, having permanent regard for the public interest, leaving these companies to actually determine what that public interest is. We do not do this with other large companies in respect of such things as trade practices or competition policy, but we do it with media companies. They get exemption from the Privacy Act provisions, which every other large company is subject to. And there is only one reason: freedom of the press. Yet when the Law Reform Commission recommended that the media exemption should be maintained, but with some tweaking for accountability, the media companies moved immediately into high dudgeon. Everything is working well is the constant and only public refrain. The fact is, the intellectual case for adoption of the Commission's modest recommendations is barely assailable, and is laid out in Chapter 42 of the report. The Commission recommended two new limitations to the exemption for acts and practices in the course of journalism. That is, a definition of journalism should be introduced for the purposes of the Privacy Act, and a small change made to the definition of a media organisation. The more significant recommendation was that media organisations should not be left entirely to themselves in setting standards, with the introduction of measures that would continue the exemption only where a media organisation was committed to adequate privacy standards developed in conjunction with the Privacy Commission and the Australian Communications and Media Authority. In other words, no longer on a good behaviour basis putting out a statement they comply, but in fact coming to a negotiated position with the Privacy Commission and the Australian Communications and Media Authority under the law. In the light of the obvious shortcomings in the current system, this seems pretty sensible to me. But let me just read you the specific recommendation of the Commission. It's 42.3. The Privacy Act should be amended to provide that media privacy standards must deal adequately with privacy. This is reasonable enough, you would have thought, that media privacy standards must deal adequately with privacy in the context of the activities of a media organisation. Recommendation 42.4, the Office of the Privacy Commissioner, in consultation with the Australian Communications and Media Authority and peak media representative bodies, should develop and publish criteria for adequate media privacy standards, and they commit themselves, criteria for adequate media privacy standards, and a template for media privacy standards that may be adopted by media organisations. Now, John Hartigan and others in defending media standards claim there are only a small number of complaints and breach findings. Now, this is actually true of formal complaints. The Press Council published 30 decisions on formal complaints between July last year and the end of May. Six concerned privacy, 2 were upheld. But importantly, we don't have figures on how many complaints are made directly to the media organisation concerned and their resolution, or the ones people feel aggrieved about but then desist from making. Factors other than the efficacy of the system may explain the low reported numbers, if in fact it is the case. Of course, many people believe there's just simply no point in doing it. One limitation on existing schemes is that complaints can usually be made only by the person directly affected by the alleged breach of privacy, although the Australian Communications and Media Authority has own motion powers, and under those apparently it's investigating the Channel 7 report regarding the David Campbell matter in Sydney. Another factor is that people don't complain because they run the risk of attracting more attention to an issue, thus compounding the problem they're dealing with in the first place. Or they believe the Press Council, despite the involvement of public members undertaking an investigation of a complaint, lacks true independence. In other words, they expose themselves, devote a ton of time and energy only to get the brush off. Perhaps there are a few complaints because most people wouldn't know what to do or where to go. Again, Dennis Muller's work from his research tells us 3% of the public know of the MEAA, while only 4% know of the Press Council. I mean, it's not on everyone's lips, the Press Council. The Australian Privacy Foundation wasn't far off the mark in stating that the whole system is ineffectual and that there are relatively few complaints because there is a widely held public perception that when it comes to privacy, the media are effectively above the law. Well, who is surprised then that the one mechanism of accountability that stands out for excellence amongst journalists is not the industry's self-regulatory bodies, but Media Watch? As Dennis Muller again told the ABC's Media Watch in his survey of journalists, Media Watch scored 9.3 on an 11-point scale, and it was by far and away the most admired of all the accountability mechanisms, and it's a television program. It's not even a properly instituted accountability mechanism. So, moving forward, as our Prime Minister might say, what could be done to improve underlying conduct in journalism while actually improving the framework? Well, first, industry leaders and the profession should acknowledge that improvements are needed. I mean, does it take that much to acknowledge that improvements are needed? Instead of standing aggressively behind the status quo, dressed in the cloak of the Fourth Estate, they need to talk more about responsibility, more about the importance of ethics, more about improvement in the standards of journalism in all respects. Well, we mightn't be able to do much about some online players, but those in the mainstream need to provide real leadership in managing themselves and any self-regulatory system. On the issue of promoting high standards and transparency, there aren't many Australian publications or broadcasters that appear to have followed the example elsewhere in various places around the world of appointing an internal ombudsman or public editor with a role to champion best practice, investigate complaints generally, and with a public platform to explain or attempt to explain news judgments by a media company or newspaper and questionable calls on privacy and other standards. We don't do any of that. On enforcement of decisions arising from the investigation of complaints, those involved in self-regulation should be aware that public and private sector organisations covered by the Privacy Act are on notice of a significant proposed step up in enforcing compliance with the law. Minister Ludwig has announced that the government will amend the Privacy Act to introduce civil penalties to be imposed by the Federal Court or the Federal Magistrates Court for, quote, serious breaches when other enforcement measures are not sufficient. The Minister said, quote, they will be serious sanctions. It is essential we have a robust system in place to protect the privacy of individuals, unquote. The existing Press Council scheme, already criticised over the lack of enforcement powers, may look even weaker in comparison to these new powers delivered under the Privacy Act. This is a separate issue from the proposed statutory cause of action and relates to an appropriate sanction following investigation by the Privacy Commissioner of compliance with the law. Let me give an example. That was the Commissioner's recent finding that Google had breached the Privacy Act by collecting unsecured Wi-Fi payload data using their Street View vehicles. So they go up and down the street, pick stuff off out of the air. They're not a media company, they're not a newspaper. And this is why the Privacy Act is important when it applies to corporations. Sanctions available to the Privacy Commissioner were previously limited to a requirement for an apology and acceptance of an undertaking to do better in the future. Under what is now proposed, every business with a turnover of more than $3 million a year will potentially be subject to such financial penalties imposed by a court. This is likely to concentrate minds on the importance of compliance with privacy principles a little more perhaps than hitherto. Media organisations outside the scope of the Act need to consider whether thrashing serious breaches of privacy, and you know this, Glenn, I'm going to use this phrase, with a warm lettuce, should continue to be all that their self-regulatory systems can deliver. And that's what they do. They give breaches of privacy a good banging with a warm lettuce to continue to see that their self-regulatory systems are up to scratch. Second, media organisations should be sending an important message about where they stand on these issues if they indicated they are prepared to work with, not against, the modest reforms proposed by the Commission for continuation of the media exemption from the Privacy Act. Third, industry and professional leaders should get back to an issue which has defied reformers for years, the idea that, with regard to ethics and standards, the media would benefit from unified arrangements, not all those ones I described earlier, 7 different arrangements, for instance, in television, but unified arrangements, consistent principles, and uniform enforcement mechanisms applying to all outlets, newspaper companies, journalists, broadcast companies, and internet service providers. And fourth, more attention to guidance, education and training will continue to be an issue, especially while some senior journalists and those to whom they report claim that the public interest is anything that the public might find interesting. The public interest means publication or non-publication guided by what is in the interest of the public as a whole, not what readers or an audience might find interesting or titillating. It's not always straightforward or easy, I think we accept that. But as mentioned previously, it's claimed to be at the centre of the media's claimed right to publish generally and said to be a central determinant in deciding that publication of sensitive material is justified. In other words, if it's got a lot of onlookers, well, therefore it's in the public interest. However, when it suits the argument, media interests seem prepared to jettison the public interest concept and the important balancing of interests that they claim to manage and get correct every day and most of the time. It's apparently too hard even for judges. The aforementioned News Limited lawyer, Justin Quill, writing in last Friday's Australian, argued the dangers to open justice from a proposed change of the law regarding suppression of court proceedings that would give judges power to impose an order where the public interest requires it. He said, how could including a power that can only be exercised in the public interest be a bad thing? And then he answered his own question by saying, the main problem with public interest is that it's a nebulous concept that is difficult to define and even more difficult to weigh against the circumstances of a case. It's the practical application that will cause the problems. Rather than abandoning the public interest, the media needs to put more time and effort into fostering a better understanding of the term, including the notion of a right to privacy within its own ranks. The last suggestion for change is for the media to get on board in a sensible discussion about a cause of action. In other words, they should take the Law Reform Commission's recommendations and be involved in the debate about a sensible cause of action for serious breaches. The case for legislation to better define legal rights in this area is that the threats to privacy are escalating dramatically, driven largely by technological change. That the common law, case-by-case exploration of whether there is a recourse for breach of privacy is a slow, piecemeal and fragmented process likely to lead to different approaches in different jurisdictions. That legislation would give effect to our international obligations under Article 17 of the International Covenant. We've signed up to that, we should give effect to it. And that the need for better protection of privacy is being recognised in comparable countries, including traditional peer law countries for Australia, such as the United Kingdom, New Zealand, Canada and parts of the United States. The door to the development of such a cause of action at common law was opened by the High Court in 2001 in the Australian Broadcasting Corporation versus Leonard Game Meats Proprietary Limited. There, a majority of the court accepted that a tort of privacy might be developed in the future, but the nature of the privacy protection and its relationship with existing causes of action was not made clear. Importantly, to date, 2 lower courts have held that such a cause of action is part of the common law of Australia. One in Queensland, where the defendant incessantly stalked a local council mayor, the other in Victoria, where the ABC published in radio news bulletins information that identified the plaintiff a victim of sexual assault. This breached the Judicial Proceedings Reports Act of 1958, a Victorian Act which makes it an offence in certain circumstances to publish information identifying the victim of a sexual offence. Indeed, Judge Hampel in the County Court of Victoria held that, in addition to breaching a statutory duty owed to the plaintiff by virtue of the Judicial Proceedings Reports Act, the ABC and 2 of its employees were liable to the plaintiff in equity for breach of confidence and in tort for invasion of privacy. In a few cases, the courts have ruled there is no cause of action for breach of privacy. In other words, we're starting to see now these pieces emerge in the common law, not just in Australia but abroad. The Australian Law Reform Commission proposal is that the present uncertainty at law should be addressed through legislation to create a general cause of action for an unwarranted serious breach of privacy. The Commission recommended that a legal action should be available to remedy a serious invasion of personal privacy. A legal action should be available to remedy a serious invasion of personal privacy where the individual had a reasonable expectation of privacy, which someone in the shower might have, and the conduct complained about would be regarded as highly offensive to a reasonable person. This is expressly what the Commission is proposing. Further, the plaintiff would have to satisfy the court in each case that the public interest in privacy outweighs other matters of public interest. So there's a very high bar here, including the interest in informing the public about matters of public concern and allowing freedom of expression. As the then President of the Commission, Professor David Weisbrot, and Deputy President Professor Les McCrimmon, who conducted the review, said at the time, the proposal sets a high hurdle for success when a media organisation is involved. In other words, frivolous or vexatious claims about privacy will be tested against these public interest matters. By including the public interest test covering only highly offensive conduct and placing the onus of proof squarely on the person complaining of the breach, the Commission has set a very high bar, taking into account the concerns of artists and media organisations about respecting freedom of the press and freedom of expression. Indeed, some privacy advocates and civil libertarians argue that we've set the bar much too high, said Professor David Weisbrot and his Deputy President. And in fact, they have set the bar high. But the fact is, their proposal is a sensible proposal. While some media voices shout outrage at the suggestion that there should be a law blocking a cause of action for breach of privacy, others, including Mark Scott, think differently. Mark Scott told the Australia's Right to Know conference in Sydney in March last year, he said, with digital surveillance, location tracking and genetic tracing becoming commonplace, there is a very firm case for the law to allow people to protect their privacy. It's a fundamental human right, he said. The Australian Law Reform Commission proposal for a new statutory right of privacy, properly worded, is a sophisticated idea worthy of serious debate. To dismiss even the need to address the issue, the need to have a thoughtful and comprehensive debate, doesn't seem to me, he said, to be in keeping with the openness and plurality of perspectives that media freedom should be about. Well, good on Mark Scott at the ABC. Mr Scott's colleagues in the industry should pick up the point. So let me conclude perhaps this way. We know in this, the age of knowledge, the age of truly mass communications, with the ubiquity of digital tools, that the occasions for incursions in the privacy of people will continue to rise exponentially. We can take the determinist view, which concedes that the privacy of all of us is now effectively gone. Or we can assert that an innate right of humanity, of indeed the human condition, is the right to individual privacy. Or as Warren and Brandeis put it over a century ago, the right to be let alone. I believe we're stronger as a society when each of us is stronger. And by stronger I mean not having important liberties shorn away from us in some revelatory information free-for-all. The social contract, which we're all subject of, involves the surrender of certain rights in exchange for other societal benefits and protections. But at the core of that contract, there cannot be and must never be derogations such that the notion of individuality is materially or permanently compromised. The essence of the dignity of each of us goes to our individuality and our primary need to be ourselves. Not ourselves shared with billions of others, not ourselves x-rayed by the new intrusive technologies, not ourselves ground to an amorphous mass of human sameness. For these reasons, privacy will always matter. Principles matter. It will matter because the right to it represents a core and inalienable human liberty. This is why it will still matter in the face of the otherwise overwhelmingly invasive technologies. in the face of the attempts by the image and news wholesalers to have us believe that we live in the age of a new normal, a normal where these astringent and corrosive facilitations are not simply to be tolerated, but accepted within a framework of powerless resignation. What the Law Reform Commission has put on offer is a proposal to remove uncertain and possibly haphazard and fragmented development of the law in favour of a unitary approach flowing from national legislation. Legislation to create a general cause of action for unwarranted and serious breaches of privacy. If in certain circumstances people had or believed they had a reasonable right to privacy and that privacy was breached, people should have a right of action in law by way of remedy. Not simply a right to complain, but a right of action. Not a right to complain to a media-run and funded industry mechanism, a right of action at law. For as David Salter reminded us, the only real regulatory power is the law. As I said, Minister Ludwig has already announced that the government will amend the Privacy Act to introduce civil penalties with serious sanctions. This will be, in Australia, a new standard for corporations. The notion, therefore, that media corporations should enjoy different self-developed and self-regulated standards instead of regulation by exemption is simply opportunist. Every day the media is out there insisting on ever higher performance standards in the community, urging the full force of the law be applied to transgressions, but not to itself. The hypocrisy, to use a John Hartigan phrase, is stomach-churning. Industry leaders and the profession itself should acknowledge that the current free-for-all cannot go on, that invading the privacy of celebrity starlets, models and sometimes ordinary non-consenting members of the public, as Jack Waterford put it, has naught to do with the public interest and everything to do with the profit flowing from the implicit consent of victims who are suborned to the revenue task. Industry leaders and media organisations should indicate they are prepared to work with and not against the modest reforms proposed by the Australian Law Reform Commission for the continuation of the media exemption from the Privacy Act, and to acknowledge that the media in general would benefit from legal clarity, consistent principles and uniform national enforcement when it comes to respect for privacy. The media's alternative is to do what the media normally does, use its muscle to bully the government into shredding the community's right to privacy, or more particularly, to have the government turn a blind eye while the media shreds the community's right to privacy. To date, governments have been pretty wary about meddling with the media, but even wary ones will pick up the public disquiet. And in this, the age of poll-driven policy, it's likely that governments will be encouraged to act, and when they do, the remedies will be sharper and more punitive. Far better for media organisations to negotiate now around the Commission's sensible and moderate proposals than wait for the counter-punch which has to come. Thank you for listening.